Live and recording.
Thank you. Well, good morning, everybody, and welcome to the June 12th Committee of Bar Examiners meeting. As a reminder, this meeting is being recorded. I am now calling this meeting to order. Devin, please call the roll.
Bolton.
Here.
Burns. Burns.
Here.
Cow.
Here.
Gongora. Kaplan. Kramer.
Here.
Lawrence. Lee.
Here.
Lacey-Walla.
Here.
Montgomery.
Here.
Reed.
Here.
Reyes.
Here.
Reyna. Silva Guzman.
Here.
Smith. Yokelson.
Here.
We have a quorum.
Thank you. We have 8 members appearing remotely today as required by the Bagley-Keene Act, Open Meeting Act. Members appearing remotely must appear visibly on camera, except if a member is unable to appear by video due to connectivity challenges. If that is the case, please provide an explanation. Members should also raise their hands when leaving and returning to the meeting if they will be absent for more than 5 minutes. First up on the agenda is a call for public comment. Before we begin public comment, I would like to remind everyone that under the Bagley-Keene Open Meeting Act, public comments must pertain to items that are on the agenda or be related to matters that are within the jurisdiction of this agency. Specifically, the committee exercises oversight on admissions matters, including the California bar exam, the first-year students bar exam, moral character applications, and law school regulation. The CBE does not have authority over attorney discipline, and no attorney discipline matters are on the agenda for today's meetings. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider those comments. The committee has received and read all the written public comments. We thank you for that. To facilitate hearing as many members of the public as possible, I encourage you not to repeat points that were made by previous speakers. We do have a full agenda for today. As a result, I'm going to exercise the option to limit each speaker's time to 2 minutes or to close public comment after 2 hours, which includes a 10-minute break, or after the first 100 speakers, whichever occurs first. For those appearing by Zoom video, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom of your screen. If you wish to address the committee, please click on the hand icon now, and the committee coordinator will call on you in the order that hands are raised. For those of you who are participating by phone, you may virtually raise your hand by pressing *9. That is the star key, then the number 9. Doing so will alert staff that you would like to make a comment, and the committee coordinator will call on you and open your microphone so that you can address the committee. For those of you who are participating from a notice location, please alert the committee member or the staff member present in the room if you would like to make a comment. Staff will have an on-screen countdown timer visible to all attendees during the duration of your public comment. The timer's 2-minute countdown will begin as soon as you start your comment. The on-screen timer will flash throughout the final 10 seconds. We will start public comment with people who are in person, starting with anyone who are at any one of our remote locations. Then we will move to those who signed up in advance. The committee coordinator will now call on members of the public who are in person at one of our remote locations. Devin, I understand we have somebody in Sacramento?
That is correct.
And this person's name?
Kai On.
Your name, sir?
Kai On.
Thank you. Sir, you have 2 minutes.
Okay. Good morning, all members. My name is Kai On from Sacramento. Political power controls State Bar of California, Chief Justice, and Attorney General, not to investigate Sacramento DA office and SPD make up a story that fake killer Zhong Shou-fang hit and run kill my father Wen Kong on. DA case number 99F08735. Sacramento City Council even used a UC Davis internship student to email me a fake police report. Political power also controlled UC Davis Law School, ignore my complaint. I ran to governor's office in Sacramento, but governor's office does not take any action. How a state government allow political power to control the government, law enforcement, and justice system to commit obstruction of justice activity. Therefore, it leads the member of State Bar Board of Trustee and other committee member to speed up and notify Senate and Assembly to look into the issue. Someone is trying to control State Bar of California and UC Davis Law School to cover up a scandal. Thank you so much for all your time. Thank you.
Thank you, sir. Next.
Our first public comment will be from Jessica Ditch.
Thank you. Devin, could you turn up your volume a little bit?
Yes, sorry.
Okay, thank you.
Hello, can
I'm
you hear
sorry.
me?
And I'm sorry, I didn't hear who the speaker is.
Jessica Ditch.
Thank
This
you.
is Jessica. Can you hear
Thank
me?
you, Miss. Yes, we can hear you. Thank you. Please, you have 2 minutes.
I've participated in the law office study program for 6 years. And over the last 2 years, I've brought to this committee's attention the deficiencies in the program, and I've offered to help improve it. As a career educator and doctoral candidate in educational leadership for equity and justice, I share today with a goal of improving biased practices. I recognize that after I paid $900 to change the name of my supervising attorney, that the State Bar has adjusted the fee to a more reasonable $200, though I'm still unclear why this is not the same as it is for the Certified Law Student Program, which is still only $32 to change the name. Law office study students participate mostly because they cannot afford law school. I also want to mention a few things needing attention. The State Bar should afford students grace for arbitrary non-published deadlines when the office itself fails to meet its own deadlines. 2, if the CBE denies a request for good cause extension for such a deadline, an explanation of the denial should be shared, and applicants should be permitted to review the closed session minutes for their own cases. 3, law office study students should be afforded Chapter 6 protections for monthly exams. 4, if the Office of Admissions staff refuses to award credit for work, the applicant must have a chance to be heard. Otherwise, as in my case, where a year and a half of my study was erased by a single staff person's misunderstanding, due process is absent. Similarly, before an applicant is referred to moral character on a staff member's misunderstanding, they should have an opportunity to be heard. While I know the admissions office is understaffed, they must also find a way to reply to applicant inquiries in a timely manner. And if anybody wants to have their matter heard in open session, as I've requested numerous times, they should be afforded that right. Finally, if the moral character application process is going to take more than a year, as it has for many applicants, students should be encouraged to submit their applications more than a year in advance. I understand you're going to be considering my petition today, and I hope it's taken very seriously. Thank you so much.
Thank you. Next,
Next public comment is from Diane Yu.
Ms. Yu, go ahead.
Hi, thank you very much for your opportunity to speak. My name is Diane Yu, the incoming dean of the School of Law for Golden Gate University. I believe on the line is my colleague, Nicholas Bradley, who's the general counsel and chief of staff to to Golden Gate University. We're both very grateful on behalf of the university for the careful consideration this Committee of Bar Examiners has given us and its approval of our California Bar Approved Law School application in January. I'm here simply to say that we are going to be filing a major change application because a number of developments have occurred since that filing. We wish we could have told you earlier, but these changes have just been developing because of these 4 changes. The first one is leadership. The second one is timing of our launch of the law school. The third is venue, and the fourth is teaching modality. So let me just turn to those if I could. First, leadership change. Golden Gate University has a new president in Brent White, who's a lawyer, and he took office November 1, 2025. In his initial months, he had to take stock of the university, including some fiscal challenges, and address issues like fiscal sustainability, improving infrastructure and the operations, and working then on program review. As a result, we have developed a clear mission for Golden Gate University, noticing that our sweet spot in higher education is serving an underserved, underrepresented group, working adults. To that end, the whole university's approach is going to be focusing on being accessible, affordable, and flexible so that we can best serve this wonderful constituency of working adults. Therefore, we are going to be making a request in the major change application to move our launch date from this fall, 2026, to fall of 2027, because the major change application does need to be approved by you, and it wouldn't be realistic to try to start. We also have moved our...
Thank you. Your time has concluded.
Sorry about that. Thank you very much for your opportunity to speak. Appreciate it.
Our next public comment is from Benjamin Cohn.
Mr. Cohen, you are recognized for 3 minutes.
Thank you. I'm commenting today about the agenda item for a status update on the CBE work plan. I believe that the work plan should define more clearly the timeline and the process for addressing how the next testing accommodations rules revision initiative is going to work. As some of you who have been on the committee for longer know, the original reason that you said you were going to not address the timeline reforms in the last initiative that started in 2022 and was determined in 2023 was that you needed 2 exam cycles of data to assess staff capacity without increasing that capacity, assuming that that would not be justified by the policy merit of timelines reforms, to see how much you could improve the timeline reforms. 2 exam cycles would have been no later than 2024, based on having started implementing what didn't directly conflict with the rules, which was most of it, pending the California Supreme Court's decision. But the California Supreme Court allowed this to go into effect without issuing a judicial determination on the merits of the proposal in 2025. So you'll have it even for exam cycles after that by your next meeting. Given that, I think that it is appropriate that a proposal be released to the public before your next meeting so that public comments can be responsive to that proposal at that meeting. And I also think that it would be appropriate to give the committee notice, at least by staff, what working group sign-up opportunities there might be if you're going to do what you did in 2022 and 2023 and basically delegate this to only a couple CBE members and staff as to what should be agendized properly and what should be considered at the meetings. If only a couple CBE members are going to have a say in this, I think that the CBE as a whole should have notice that that's when that sign-up opportunity opens, and make sure that those interested have the opportunity to participate, hopefully more than 2 of you. And hopefully if it is a very small number of you, it's still everyone who wanted to participate and not those staff would prefer deciding what gets in this next proposal that comes back to the rest of the CBE. All right, thank you.
We do not have any additional raised hands, and I'd like to note for the record that committee members Kareem Gangora and Julianne Smith are now present.
Thank you. Thank you. All right, thank you for your public comments, and this concludes the public comment period. So the next item on our agenda is the chair's report. Just a couple of items from me today. First, you will recall that when we last met in April, CBE approved a recommendation for the Supreme Court on the bar exam to be administered in the future. In mid-May, the Board of Trustees concurred with our recommendation. The formal petition forwarding what is now a joint recommendation and the accompanying risk-benefit analysis was submitted to the court, to the Supreme Court last week? Last week. We expect the court to issue its orders in mid-May, leaving us sufficient time to meet our statutory notice requirements. Also, you'll notice that item 4.5 was withdrawn from the agenda. Item 4.5 was intended as a discussion of a notice of noncompliance with Pacific American University School of Law. The item was withdrawn because PAU has voluntarily withdrawn its registration. It will not be operating as an unaccredited law school in California unless and until it comes back and submits a new application, and unless and until the CBE approves that application. And with that, I will close my chair's report. Next item on the agenda is the approval of the minutes, open meeting minutes from April 17th and 18th, 2026, Committee of Bar Examiner meeting. Do we have any questions or are there any revisions to the minutes? Seeing
I'll
none.
make the motion to approve.
I'll second that motion.
All right, who moved? Kareem?
Yeah.
Kareem, okay, and Michael Cow seconded. Devin, please call the roll.
Bolton,
Yes.
Yes.
Cow,
Yes.
Gongora,
Yes.
Kaplan not present, Kramer,
Yes.
Lawrence not present, Lee,
Yes.
Masiwala,
Yes.
Montgomery,
Yes.
Reed,
Yes.
Reyes,
Yes.
Reyna not present, Silva Guzman,
Yes.
Smith,
Yes.
Yokelson.
Yes.
With 13 ayes and 0 nays, the motion carries.
Excellent. Moving right along, item 3.1, the consent calendar. There's one item on the consent calendar, the administrative updates regarding law schools. Do any members wish to pull this item off the consent calendar?
Yeah, just ask Natalie one question.
Sure. Natalie?
She
Are you Natalie Leonard?
We will promote Natalie.
I'm sorry, what, Devin?
We're promoting Natalie so she
Okay.
can answer.
Bring her on.
So Natalie, you mentioned the changes in the federal student loan program, but could you just be ever so briefly explain the practical impact of those on our law students in California?
Yes, I'm definitely not the expert of DOE policy, but generally, there are going to be $50,000 per year, $200,000 caps for professional loans, including those for JD programs. And there is also a narrowing of the option for Parent Plus loans to the extent that people are choosing those. And there are significant modifications to repayment programs for those that choose public or legal aid careers.
Meant to further encourage people to go into those careers?
Yes,
Or-
so the terms of loan repayment and loan forgiveness have changed and have also been significantly extended. The time
Okay, so the
period,
incentive is increased.
well, actually, the time period to work off the loan period is longer than it was before.
Okay, so that's a net disincentive then.
Right, and for those that had already started their JD program prior to July 1, they will continue to operate under the old rules. For those that begin their JD program after July 1, they will do so under these new rules.
Thank you.
Welcome.
Thank you. Does anybody else have any thoughts, comments? Seeing none, do I have a motion to approve item 3.1?
I'll make the motion.
Moved by Kramer. Is there a second?
I'll second. This is Justice Maciwala.
Justice Masiwala seconds. Thank you. Devin, please call the roll.
Bolton,
Yes.
Burns,
Yes.
Cow,
Yes.
Gongora,
Yes.
Kaplan, not present. Kramer,
Yes.
Lawrence, not present. Lee,
Yes.
Maciwala,
Yes.
Montgomery,
Yes.
Reed,
Yes.
Reyes,
Yes.
Reyna, not present. Silva Guzman,
Yes.
Smith,
Yes.
Yokelson.
Yes.
With 13 ayes and 0 nays, the motion carries.
Thank you. Item 4.1, next on the agenda is discussion and action, if appropriate, on revisions to the unaccredited law school rules. This item is being presented by Office of Admissions Principal Program and Analyst Natalie Leonard. Natalie, you have the floor.
Thank you. Good to see everyone again. So I want to talk about the unaccredited rules proposal. For those of you that have served on the committee for a while, this will look very familiar. This is something that we were working on actively in 2024. And then at that time, there was an overall pause on rules revisions in general. We were planning to go in line behind the eligibility rules. We have determined that we can go forward with this portion of the rules, though the eligibility rules updates are still pending. As a reminder, around every 5 years or so, we do just go ahead and review the rules and see if there is anything that is needed. So this proposal that you'll see here is a combination of the requests that were made or the questions that were asked from both the Committee of Bar Examiners and CS Bars, as well as staff since the last revision. So just thinking about the purpose of unaccredited schools in general, in California, we have not only ABA approved schools, but also 2 categories of non-ABA schools as well. So why is there an unaccredited program? Many of you know historically, this was actually operated out of a separate, now sunsetted agency. It came here to the State Bar in 2008. As we see changes in the legal education area, as we see expansion of some types of education that were primarily limited only to unaccredited before, such as correspondence/asynchronous education and online education, some members of the Board of Trustees have wondered what is the role should this category continue? And the CBE has said, let's look at what the rule set is, how it can be updated, make sure. The other thing that we just do generally when we do a rules revision is make sure the rules are operating effectively and efficiently. And we probably have never seen so many changes in legal education and accreditation as we've seen in the last 2 to 5 years and what we think will be coming up as well. Let's go to the next slide. So these rules that you see are a product of a lot of thought and study. But again, as I mentioned, the last time they were brought here to the committee in December 2024, a lot has happened since then. So the proposal that we'll share today is definitely available for review, for discussion, for modification. But it was the product of quite a few meetings before, not only with staff, but also with some committee members and extensively with CS Bars. And the version that you see now includes the comment that came from CS Bars at that time, and the staff agenda relating to it also summarizes that feedback. Most recently, CS Bars has been reviewing these rules and commenting over the last 2 meetings in April and June. And they also wanted this format to ensure that the public and the deans that participate from the audience in CS Bars would have an opportunity to comment as well. In addition, we keep COAF updated, the Council on Access and Fairness, and they have been very supportive and helpful in both unaccredited and accredited rules revisions. Next slide. So in terms of timelines, CS Bars plans to see these rules one more time in August. Here at the CBE, we're refreshing everyone or acquainting some members for the first time as to the status of the rules. We'll bring this back to you in August to review the rules and potentially the guidelines. And then October, you'll see if you believe it's appropriate to recommend these rules proposals to the Board of Trustees for posting for public comment and approval. Next slide. Inside of the presentation here is a link to the version at that time. You'll be able to see the staff agenda and the version of the rules. You'll see a red line version as well as a clean copy. What I'm going to actually do is just summarize the directional points for your comment and also just to ask you if you have other strategic questions you want us to be able to think about in the rules revision when staff is preparing support materials for you. Next slide. Just quickly summarizing the key modifications, we'll talk about each one briefly. Number one focus is really to streamline the non-compliance process. And that's not to do anything other than reduce duplication in the current process. When the current, well, and I'll talk about it more in a moment, but right now schools are doing double work in a non-compliance situation. We've created a new format for the unaccredited rules that has been working well, thinking about applying it here. We're also hoping to improve clarity for questions about consumer disclosures and financial disclosures for means that were not relevant before, but have become much more so. And also clarifying the requirements for major changes, student complaints. More recently, you know that we've been talking about modernizing the categories, thinking about the acquiescence requirements for a wide range of non-JD programs that schools are interested in offering, and also emphasizing that the primary purpose of supporting students is supporting students to take the California bar exam and license. Next slide. Okay, we'll have several slides here to talk about this part. For unaccredited law schools, they gain their authority to establish bar exam eligibility by complying with Business and Professions Code 6060. Briefly, there are two ways to do so, and you can see that in the sub-bullet points here. 4 years of study, at a law school with 270 credit hours per year. Historically, that's been brick and mortar in-person study, or 864 hours of asynchronous or synchronous preparation logged each year for 4 years. So right now you have 3 categories: fixed facility, in-person only, and then the 864-hour category has been split into distance learning and correspondence. There was a time when those things were very different, and when these rules were originally written, correspondence literally meant corresponding, putting the materials in a box, receiving the box, sending the box back. So there was a wide gap between that. These days, we don't see as much. We see correspondence asynchronous as one choice for most schools, or a live presentation, fixed facility, or synchronous distance learning. That's what the market seems to want, what schools seem to want to do. Next slide. So for those who would like a visual representation, what we would propose going forward is that schools that are in the correspondence category now and offer asynchronous on-demand education would become asynchronous as their category. Schools that are fixed facility, I go into the classroom, would become synchronous, and distance learning would have a choice, depending on whether they are largely delivering live presentations or taped presentations. We set the threshold for now at 80%. We know that accredited law schools have much more mixed modality than that, but it has always been true, and it has been aligned with the statute that unaccredited schools, when they're launching, choose one modality, so they know whether they're under the 270 standard or the 864 standard. Next slide. The statutory references are here. 6060E2 has the eligibility area. A and D are the fixed facility. and the correspondence / asynchronous. I just want to pause a moment to see if Vince or Paul or any other members have any comments or questions about this, or about the 80% proposed target.
Yeah, I do think that targets may require more exploration. Because we did get pushback in one of the public comments for this meeting about, well, frankly, arguing against setting any kind of target one way or another and allowing ultimate flexibility to the schools. So we're going to need to know how practical it is for our staff to be able to review and and monitor something like that before we well, as a part of setting this standard, if we're going to have one.
Thanks, Paul. And one of the things we talked about doing at the CS Bars on Wednesday is reaching out to each law school, each current unaccredited law school, and getting a sense of how this might affect them. And the particular public comment that we received was actually from an accredited law school that does a fully asynchronous modality. So there might have been some confusion as to whether or not this applied to that law school, but it would not, because that school is a CALS. Michael?
Well, thank you. There's a question on the distinction for asynchronous delivery. Do we draw a distinction on whether the delivery is something like the professor would record a lecture and then the students could watch it anytime during the week, or that there's just a bank of recorded lectures that are used year over year over year? I'm wondering if there may be a distinction on whether I just have just a canned contracts lecturer that's years and years old that I just keep rerunning the video, versus if it was asynchronous but it's new content every semester that's tailored, maybe I'm less concerned about tailored content, but people view it on their own time.
Mm-hmm. It depends on the school. For the schools that choose to reuse lectures, that most often happens in a case where the same professor is teaching year by year.
Sure.
And when, as part of the inspection process, we ask the schools to demonstrate what their review process is to ensure that if a lecture is reused, it's still not only has current content, but it's also current relative to bar exam eligibility or other rule changes.
Excellent. Thank you so much.
You're welcome. Okay. All right, let's go on to the next. Here's a policy question that I would urge you to think about, sharing your feedback today or as we prepare for a further discussion in August. So here is a new factor that has been increasing in prominence in recent years. Online education allows schools to enroll students who never intended to license in California. There is a certain DOE regulation that somewhat applies to this, but the State Bar is not subject to the DOE regulations, and not every school in the California portfolio is either. Recently, taking it a step further, several programs expressed an interest in focusing on recruiting students specifically outside the US. So they would be headquartered in California, but their students would actually not only be outside of California, but outside of US jurisdiction. We've also seen some other states, notably Connecticut and Washington, think about allowing direct eligibility for those graduating from CALS and potentially unaccredited law schools. So I want to remind everyone that the CBE and the Board of Trustees have made a decision to subsidize law school regulation as part of the mission to support licensure in California. And historically, up until the present time, all of the efforts of these schools were focused on getting students ready to take the California bar exam, but we may see that change. So I want you to think about three possibilities. What do you think is the appropriate direction for the future? which should we have schools supporting only California licensure, and by that service to Californians needing legal assistance? Number two, should schools be allowed to set goals to enroll students from any geography? And if so, should the possible subsidization be reconsidered if that subsidization is now also subsidizing non-California licensure or even international licensure? And then finally, what about the role of schools that are cited in California, but recruiting students elsewhere, either incidentally or as a sole focus? So it's not at the point that we are doing a rules revision. This can come back and we can talk about that as part, but there is an element of the rule statement right now that talks about the importance of a California administrative headquarters, as well as a focus on California licensure. Paul and Vince, any comments or thoughts here as I post the actual wording?
Natalie, this is Julie. I just had a quick question. What you mean specifically by subsidizing? Do you mean just the costs of the program itself? Or do you mean that these schools are charged less than other schools?
Oh, okay. So right now, schools pay an annual accreditation services fee to the state bar for the regulatory work that the state bar does. That fee does not cover the full cost of the regulation. There was a decision about whether to do so. And in the most recent fee adjustment, the gap was narrowed, but other admissions programs do subsidize legal regulation of the law schools. So it's not a tuition subsidy, it's subsidization of the cost of accreditation services.
And so schools in other categories do pay enough where that's covering the cost of their regulations, just this category where they're being subsidized. Is that correct?
It's actually an overall subsidy for both CALs and unaccredited. And depending on the direction that you take here, this could affect the fees for both unaccredited and accredited.
Thanks, Natalie.
You're welcome. Okay, next slide.
Well, hold on.
Oh, come back.
I was going to try to go last. Sounds like I may be the only other person to comment.
Okay.
I've always been in favor of charging the actual cost of services to the recipients. It's just kind of a fundamental principle of economics for me. So I was against the subsidization that we've done to this point. I would say that it would be difficult, or actually we'd probably add to the costs significantly if we tried to develop some sort of way where we could identify the schools that aren't producing California lawyers and charge them more. Just the record keeping on that and the review of the information, the cost of bar staff doing that would probably eat up any additional revenues that we would receive. So I would be in favor of charging them the actual cost, and then whether they're licensing people for California or elsewhere that doesn't seem to me to matter.
Thanks, Paul. Michael?
I also agree that they should be paying actual cost. I think that's something that is too much for the bar to subsidize. For me, it is a bit of concern that if they are not producing California attorneys, then that program perhaps should be regulated by other higher education standards associations and not the state bar. State bar is the mandate is to protect the public through the administration of the Bar Association, not running colleges and universities and postgraduate programs. So if we aren't producing California lawyers, then it's not within our purview to be running this program.
It's probably never going to be as clear cut as that, though, Michael. There'll be some California applicants, maybe just a few from any program and, many others that go elsewhere, but
I think by using the bar passage rates, people do need to be passing the bar, and if you have a level of attrition, well, perhaps we apply that.
I think that would just be difficult. But and then in our experience, Natalie, is it fair to say we're not so sure that there are others ready to take up that task? We would be saying to those schools, Michael, that your graduates can't sit for our bar or be admitted to our bar. And would we want to do that?
No, I think the opposite. I think we say for the unaccredited program, we want you to sit for the bar. We need you to sit for the bar in high numbers. If you fail to do that, we have a problem.
And potentially something we could bring back to you for the future is a little bit more information. There are many states that are actively discussing or actively piloting right now, but the number is fairly small. So the first other 4 or 5 graduates took the bar exam in Indiana. The pilot just started in Connecticut, small number in Texas. We could bring back a little bit more data in this area to help you think about it as it's time to do fee discussions in the future.
Because the concern is if everyone goes through the education in California, we absorb the administrative cost of running the program, and then everybody takes the bar in Washington.
Yes. Yes. So I'll speak up. This is Donna. Michael, that's absolutely a big part of the concern. To the extent that other states are relaxing their rules and are allowing people from non-ABA law schools to sit for the bar. But if California is one of the only places that is regulating these law schools, then we do worry about, is there going to be an influx of work that we have to handle? We've got to take care of the administration and the regulation of these programs that are designed for the purpose of allowing people to sit for the bar in pick a state. I don't want to sound like I'm discriminating against any state or any other country. We have seen a couple of programs now that have applied to us that are geared toward providing a JD from a California law school to people in other countries that arguably, it seems to us from the materials, don't have any intention of sitting for the California bar or any bar in the United States, but that it is a certain advantage to them to have a JD from a California law school. And so to the extent that we are not, as you, I think, very nicely described, sort of supporting our mission and increasing the number of lawyers potentially available to provide legal services to people in California, it's a policy call on whether that is an appropriate use of our administrative time and efforts to regulate these law schools.
Thank you so much, Donna. That was exactly my consideration, so I appreciate it. Thank you.
Thank you. Let's go on to the next slide. Just briefly with the non-compliance process, the issue in the unaccredited rules is that if a significant non-compliance is observed during an inspection, there's a warning process with warning letters and responses, and then a non-compliance process. But the steps of those processes are very similar. And as a result, you receive, the schools must create similar responses, and you must review similar responses. So the proposal has a unified process that removes the duplication without limiting your effective oversight in any way. This seems to be working well in the accredited portfolio. Fortunately, we haven't had schools use it extensively, but it seems to be very clear. And this is something that was talked about quite a bit before it was implemented for the CALS program, and we think it would be successful here.
Yeah, this came to a head for me when we had a law school that had very few students, maybe none at the time, and the owner operator just basically left the country. And we had to have the various steps of the process on our agenda for maybe 5 or 6 separate meetings in order to close the law school. And so this new process will allow that to happen more expeditiously with less committee time being taken up by, steps that could be collapsed into single steps.
Thanks, Paul. Appreciate your leadership here as well. Okay, next slide. With respect to the disclosures have always been clear, but we've made a couple of enhancements, one already implemented. The cumulative bar exam pass rates are now calculated using the same formula on disclosures, whether the schools are unaccredited or accredited, so that prospective students can do a direct comparison. And we are also proposing some modifications to the financial disclosure rules, complaint process, and major change requirements based on comments that we've received. Essentially, new things are possible. In particular, schools were primarily standalone before, but now in many cases they're part of a university. We've been getting more questions about the formal student complaint process, and we address it here. And the types of major changes people have requested have been changing. So we're just clarifying the rules. Next slide. In addition, there's a suggestion to enhance the acquiescence requirement. As a reminder, the state bar jurisdiction is solely over the content and quality of the JD program, but you do review other programs in the law school at the acquiescence level. So can the law school operate these other programs without damaging or affecting the compliance of the JD program? Historically, these other programs were only degree granting programs, but these days we see more micro-credentials, non-degree reviews, etc. And so this gives you some visibility into those that you don't have today. Okay, next slide. There are also just general cleanup changes, consistent terminology, consolidating the definitions, and ensuring that that requirements are placed in the rules and interpretations are placed in the guidelines. We are close to the end. Next slide. Also, just a reminder, recently you discussed the artificial intelligence proposal. And so we're looking at 2 possibilities, certainly adding artificial intelligence and technology to the possible choices for competency training for new lawyers in JD programs, and potentially adding it to the professional responsibility requirement as well. Although there were more points of view about whether or not that was the right way to go forward or to keep that class focused on the MPRE. Next slide. Are there any questions just generally, or are there any topics that come to mind, particularly from those members that may have attended an inspection, for which we are grateful, and we know that the schools appreciate your participation in those as well? Okay, well, that concludes this presentation for today.
All right, thank you. This is not contemplated as an action item today. We just like committee members to think about this, and it will come back at a future meeting. So next on our agenda is item 4.2, discussion and, if appropriate, action on exploration of performance targets for key indicators of the law school performance. Again, Natalie, you have the floor.
Okay, thank you. So this is a strategy discussion designed to get everyone on the same page prior to releasing the 2025 Law School Performance Report, which will come back to you in August. So far, we've researched metrics that are used by ABA and institutional accreditors, as well as what we've historically used in our own performance report. And in your work plan, you ask the question, should we be developing performance targets for key indicators of law school performance based on this additional data that you've begun to collect and that has finally reached the point of trended information. So that's why we're thinking about this now. You have trend information that you never had before about law school performance. So we'll be talking about performance metrics and potential types of targets you could have. And next discussion, we'll talk about the data to inform what those targets would look like right now. Thanks. Just for us to get on the same page, difference between characteristics and performance metrics. Right now, in the annual reports or periodic compliance reports, we collect characteristics, attributes of law schools, and we also collect performance metrics, which are about
Devin, can you hear us?
I can. I think Natalie dropped off. She's in the office next to me, so let me go see what's going on. 1 second.
All right, thank you, Devin. Oop. The low technology approach.
It's true. Okay, so these are the measures some of the measures that we collect right now in the annual report process. Next slide. The next few slides are information and data regarding the schools and how they've been performing using this 3-year trend, which is relatively new. You saw this for the first time last time, reminding you of the trends here. So here we're looking at first-year attrition rate by student-reported, self-reported reason, by law school type. And you see the Cal's attrition is relatively stable, generally falling a bit. Most recently, we've seen an uptick in the unaccredited law school attrition. So that's something we've been talking a lot with the schools about in inspections. Here are the first-year law students' exam pass rates. Remember that this data includes a trend, including an inflection point where the format moved from a combination of essay and multiple choice to multiple choice only. When that first happened, we saw a rise in the pass rate, an initial rise that appears to have settled out. One thing that you've talked about in the past is potentially a minimum first-year law students exam pass rate. This is a much more nuanced number than the cumulative pass rate that you use for the bar exam, just because of the choices that students have with respect to the first-year exam. For those that are subject to the requirement, they need to take and pass it within 3 administrations. Some withdraw from school until they pass. Others continue to study. Some take all 3 opportunities and some wait. So it's a little more challenging to set a minimum here, but it's certainly something we could explore. And a great way to do that is through a target. Next slide.
Natalie?
Yeah.
Do we keep data for how many pass within the first 3 attempts?
I don't have that overall data. That's something I can look into seeing whether it's possible to collect.
Yeah, well, we must be able to pull it up from the database, but I wonder if that might provide us with some useful information.
I can preliminarily give you some information from the second-year attrition, which includes a first-year law students exam qualifier, but we might be able to get something a bit more clear.
Okay, if you think it's provides some useful information.
Okay.
And Natalie, can I ask a question on that last slide if we can go back? And
Sure.
This is my ignorance more than anything. These numbers seem extremely low, right? If the pass rate is generally less than 50%, is that what's expected?
Historically, this pass rate has been in the 20 to 25% range. That's usually what we have seen. And so these numbers are actually, the bump that you see in 2024 is actually a little bit higher.
And
But this
again,
is
this is out of ignorance. What happens when you don't pass?
Well, remember this. Well, so what happens is this. If you are subject to this requirement, this means that you've gone to an unaccredited law school, or you are a special student, so you've qualified other than through college credits, and you have 3 opportunities to do so. So if I finish the school year now, I finish in May of 2026, I'll be able to take the exam 3 times. And if I pass in one of those 3 opportunities, I continue. If I don't pass within those 3 opportunities, then I am dismissed from law school at that time, but I can continue to take the exam and then reapply upon passing it. So this is so much like when you look at the NPR, you will see individual CALS pass rates anywhere from 10 to 30% generally. But then when you look on a cumulative basis, the number would be higher. And that gets back a little bit more to what Paul was saying.
Yeah, and this is a broader discussion about the program. It would seem to me from like almost a consumer perspective that if, fewer than half of the people that go through this process aren't able to pass, that tells us something about the unaccredited process and setting students up for success. So these numbers could completely caught me off guard, but I am also new to the California bar exam and need to do more due diligence.
There's another category that you don't see here, um, and you would see it particularly with ABA, but sometimes with Cal students. Sometimes if a student is academically disqualified at any point in the process, they may also be asked to take this exam. So it would be a targeted population of those that had already been academically disqualified.
And Natalie, Donna just explained this to me, but on the first line, the CALs, generally students at Cal accredited schools do not take the first year bar exam. So why do we have percentages here?
Yeah, okay. Reason for that is twofold. So for these CALS takers, almost exclusively, these will be individuals that did not have 2 years of college. They got their college credits through CLEP exams, or they were academically disqualified. And those would be the only possibilities. There are some schools, a couple of CALs, that instituted a requirement, but we're working with them to modify and step away from that. So with CALS, you're specifically seeing a differently prepared population and largely an academically disqualified population.
Thank you.
Most of the rest of the CALs, nearly all of the JD students earn their exemption by successfully completing the first year and advancing to the second year, well over 90%.
Wait, of the CALs?
Uh-huh. Yeah, almost all of the CALs earn their exemption. The CAL students earn their exemption that way, and they do not take this first year law students exam. So this is a very tiny subset of CAL students taking this exam.
Thank you, Natalie.
And just to provide a little bit more context for the newer members for the question that Crosby asked, the schools would tell you that they are opportunity schools. The student body at the unaccredited schools and for to a large percentage the CALs as well are mid-career students. They work, they have family obligations, and so the CALs and the unaccredited law schools provide an opportunity for them through online programs or in areas that ABA law schools are not, and at a cheaper, somewhat cheaper tuition rate, or in some cases significantly cheaper tuition rate to go to law school. However, as you've heard us talk about as we do review our inspection reports, regardless, we are looking for schools to provide a sound program of legal education and to admit students who have a reasonable chance of success. And so there is this tension that I think many committee members and many staff have struggled with looking at it exactly from the perspective, Crosby, that you'd mentioned, a consumer protection standard. If there's a significant percentage of the students who do not have an opportunity to proceed beyond the first year because they are unable to pass the exam, is it, are we doing harm to consumers by allowing them to attend? But on the other hand, there are significant disclosure requirements, and the schools have to disclose pass rates. They have to disclose information about their schools, and if they do that, then an argument could be made. Well, then they are disclosing that on their website. The public, who are looking to go to the law school, are making a choice based on that information, and so one of the things that we certainly always think about is, are the disclosures sufficient to provide that sort of element of consumer protection, or is there some other way that we need to be looking at it? But it is this sort of balance, I think. Let the market sort of control with these disclosures, or should we sort of step in from a consumer protection angle? At what point is it sort of patriarchal to do that if the disclosures are sufficient? So it really is a very challenging issue, a challenging debate to have, but it's certainly one that I think the committee, when we look at the performance report in August, we'll probably want to engage a little bit more in that discussion.
I appreciate, Donna, the much better articulation of that tension that I was trying to articulate myself. And, throughout this conversation, I've been in this performance management KPI world for 2 decades, and I'm always kind of thinking, okay, what is this data telling me, and how are we going to use it, or how is it being used? I generally think governments over-collect data for the sake of collecting it and dashboarding it. And so I'm going to be looking at the rest of the presentation on, okay, what decisions can this body make, or what value are these KPIs or potential KPIs going to bring to the broader guild that we run?
Thanks, Crosby.
Thank you. Natalie, go ahead.
Okay. Here, this is just overall contribution of the schools by type. So you see 56 JDs awarded in the unaccredited program, which is a small number of schools, 589 awarded through the CALS program. So there are 8 schools in the unaccredited portion, 16 in the CALS. Next slide. Okay, this is a trend of just the July bar exam pass rates. I'm happy to say that over the last 3 years, we see a pass rate trending up for both the unaccredited and accredited. And that gets back to also, Crosby, the individual pass rate you can see there. So the schools are working against a 40% minimum in Cal's portfolio. Most of them are in the 60 to 70%, well above that minimum. But you can see the individual pass rates for a single exam are lower. It's taking them a little bit of time to do so, but they're doing so. Next slide. Here, I want you to think about employment and the way employment is collected. So by comparison, employment and placement after law school is a key measure that the Department of Education uses. And part of what they're doing is saying, is this a program that will qualify students to practice in their chosen field? And more practically, is this a program that will allow students to repay their loans if they're participating in DOE Title IV programs? For CALS and unaccredited schools, you look at a 3-year lag. So this year, we go back 3 graduation years, and we ask that population, over the last 3 years, have you been in a JD required position or a JD advantage position? And we ask them to self-report. Right now, about half of alumni are reporting in, so I would consider this data only directional. Understand that level. And then also, do you need data that is more updated, more recent classes than what you see here? So that's something we could think about during this reporting. Okay. NPR, I think most people are familiar with that. For the cows right now, you have a 40% minimum. You've talked in this body about thinking um, about expanding that or expanding a modified number to unaccredited law schools, encouraging them to work toward this. Although as a practical matter, I think that most of the schools last year would have met this target. And then also thinking about the access and diversity programs at the schools for the accredited, they require well-articulated metrics that CALs use and apply. The schools in the unaccredited portfolio have talked about adding their own measures here. And we talk about these in the inspections. Next slide. So we want to bring to you the idea of thinking about building targets. Now that you have the data, getting back to what Crosby was saying, you've had goals and thoughts in doing so. How can we put this data to work at a more, already it is doing so, but at a greater power, greater efficiency situation to think about targets so you can understand and monitor what's going on at the law schools. You can telegraph more clearly your expectations for performance for the law schools, so that can help them to adjust their priorities as well. And the idea behind a target, rather than a specific imposed limit at this time, will allow you to learn in the process. It'll allow the schools to show you what they can do on their own, and it will allow you to have a rudder that will guide the schools when you are looking at competing priorities. In the upcoming years, we'll see a significant expansion of online programs. You'll see an announcement of the July 2028 and beyond bar exam. We've seen schools adjust to the multiple choice um, format of the first year law students exam, but none of these require you to wait for the moment where everything is settled. We don't know when that will be, but a target can allow you to learn along the way, but also to send protective signals. In particular, where have you talked about targets before? The area of attrition, and we've covered some of these possibilities in here. But Paul, I know that you have some thoughts about attrition targets. Or you may not at this time. Okay, so we're talking about what
Now,
is the, oh
okay,
yeah,
hold on.
I knew you did.
Yeah, I'm of the mind that we shouldn't wait for another well, for the new bar exam, whatever it is, to be in effect, and a few years after that to see how things shake out. The law schools are reasonably expected, in my opinion, to be teaching to the current exam or qualifying students. Actually, I just misspoke there because one of my complaints about some of our law schools and the system is that at times they appear to be just teaching to the exam rather than creating well-rounded thinkers who can be effective lawyers. But I don't see the changes that are coming in the bar exam as a reason to stop for a while. We should work together to come to an understanding, which is going to be difficult. But I think Donna pretty well articulated the conundrum. Do we protect people from wasting money, or do we allow them the maximum ability to achieve their dreams, however unrealistic those dreams might be? But I'm certainly in favor of starting to talk about it. Any target we bring into focus now would be something that, if a school doesn't measure up to it, I would expect that we would give them time to try to improve their results. But at some point, we would say, "Hey, sorry, but you're not meeting our standard, and that's a problem, and we're gonna have to deal with it by perhaps even closing the school.
And just to give a little bit of context, in the ABA portfolio, if a school has 20% total or more attrition over a 3-year period, it presumptively triggers an investigation. One thing that is true is that these would largely be full-time students. It'll be interesting to see that as more schools add more part-time programs in the ABA portfolio, if we see that number change or if the ABA thinks about adjusting their standard. But right now, you're seeing a range of different attrition rates, but we will bring to you some that are relatively high at some places, as many as 50 to 70% attrition in the first or second year. And so I think that many members and also members of the Board of Trustees have considered this an important area to act and to speak out. Next slide.
Yeah, there's another conundrum is this, the schools tell us that they cannot be responsible for people who leave due to what they call life events, say a job loss, they're moving, major health issues, things like that. But they also tell us that they really can't track that for us. Because I'd be open to being more concerned about people who were admitted to the program that really had no business being there because they just weren't likely to succeed versus those who changed their mind. For instance, somebody who understood what law practice is mostly from television might decide it's not for them after spending a year in the first year law classes, and that's, to me, that's a reasonable choice, and I wouldn't necessarily ding the school for that, so long as that person wasn't unqualified and let in even in that situation.
And as part of the inspection process, we've been working with the schools looking at how they communicate to prospective students. If they tell them what's required, if they tell them what success factors or speed bumps have been, and if their application is clear and tailored to their program. So that's part of the way we've been moving the needle as well. Next slide. Thanks. We talked a little bit about potentially a first-year law students exam minimum. This would probably be a complicated number to create, but it could be an area where looking at some data targets over time could be very instructive. Next slide. So in terms of timing, we talked about some conceptual discussions today. We'll be going back and taking your feedback and CS BAR's feedback and bringing you a somewhat updated version than what you saw in December 2024, but that also means there's time for your feedback and your questions, which we would welcome over the next couple of months. And then hopefully by October, you might be ready to recommend a proposal to the Board of Trustees. So just to recap some of the things we talked about some of the recent trends in metrics. And I wanted to get your opinion about the idea of a non-binding target as a way to send a signal, but also to learn.
Ashley's got a question.
Less of a question, but I think I would be heavily in agreement to some non-binding targets, especially in advance of any kind of binding targets, just to get that analysis a little deeper. I think it sounds like Paul thinks that it's a good idea as well. So that's where I stand on this.
Okay. Well, what do you mean by maybe we need to be real clear about what we mean by non-binding. Because when I hear that, I say, choose to follow it or not. So we're not telegraphing to the schools that at some point in the future, this is something we expect you to achieve, and you should start working towards that goal. We're really just gathering data and kicking the can down the road about whether we ultimately mean to enforce some sort of standard.
I saw them more as like goalposts to prepare them in advance of an actual binding target. And I mean, maybe that was not the understanding, but I think that would be the best way to handle it, is to communicate clearly that these are initially kind of like a sunset period, a sundown period that we would have. So it would prepare them for, the expectations of what they would have to report and adhere to in advance, but they're not, shocked by all of a sudden they have to be in compliance with these new goals and goalposts.
Calling it a future expectation, would that be better or clearer?
I think it will also give you one of the things that we've been talking about at the staff level. I like Ashley's terminology of sort of goalposts, because we'll have information. We have information now. You'll have information in the performance report that we present to you in August, which has the updated numbers from what Natalie showed you today. That gives you sort of an aggregate understanding of performance. And based on that, we can set these goalposts. And we'll look at them for arguably, potentially we could look at them for a couple of years now, school by school, seeing how each school is doing toward meeting that target. And then maybe what you observe is, hey, 90% of the schools are at this level. There are 10% that aren't. So this seems like an entirely appropriate level to set this at, and now we know we've got to really work with those schools that are below it, and that they have we make this a binding target for compliance purposes, because we do have data that it is an appropriate and fair target based on that experience. Obviously, we can disaggregate the information that we present to you also next week to sort of show you how the individual schools perform on some of those targets. But it would be sort of setting that target, as you say, a goalpost for the schools to achieve. We can see how they're doing and then use that information to set the compliance target in rules going forward.
Thanks, Donna. Yeah, and really, this process, to Crosby's point, is to give you the information to monitor, but also to set expectations for the law schools. And it is a moment to think about those expectations in light of the market, in light of strategy, in light of changes. This is also a good opportunity to think about any questions where you would like to solicit feedback from CS bars. So one thing you've already indicated is to get information from the unaccredited law schools about a threshold if a synchronous and asynchronous set of categories were designed. And you may have other questions to submit to CS bars as well. They are already ready to discuss in August. Okay, well,
Hey, Natalie, I have some observations, but if we're still on the topic of what we were just discussing, I don't want to move on. Sounds like we're ready to move on now.
No, go ahead, Crosby.
Okay, fantastic. So, as I think about the performance measures of the California Bar, and I think about our mission, which is obviously protecting the public, it's almost a preventative mission, right? Preventing harm from unscrupulous actors and making sure we have high quality lawyers. I would love to see and maybe do some research on what are more outcomes-based KPIs to see if we're meeting those outcomes. So, and I'm not an expert of this field, but what comes to mind is, what are the number of civil suits against lawyers for malfeasance? What is, for example, the misconduct rate or, violations around, client-bearing trusts? I'm sure there's some measures out there that can actually say, hey, as a guild, as a consumer protection organization, are we actually meeting the outcomes? Because a lot of what we're doing right now is obviously in our locus of control. We are the California Bar. We're measuring what we have. But at the end of the day, I would love to see, are we actually achieving, are the activities that we are pursuing, such as administering the bar exam, yielding the expected outcomes we would have? And how does that compare across different jurisdictions? And then the other bucket that I would add in here is behavioral, sentiment, market, brand. right? I would love to start the conversation among lawyers, among maybe even judges, among the broader public on what is the perception of the California bar, both from like a brand perspective, or do people believe it's meeting its mission? And then more experiential. So for those who are going through the bar exam, or going through some accreditation program, or going through some moral character, even, even if it's something that's punitive, how is that experience, right? One of the examples I will give you is here in Marin County, I was buying a bicycle and I saw a Marin County Ag Weights and Measures sign that said, if you don't get a receipt, something, something, blah, blah, blah. And I actually asked about that. And they said, oh, yeah, we just got an inspection because someone complained about the price not being right. And I asked, how was that? Because it's a nasty thing to have some county government employee come in and inspect you. And he's like, it was a great experience, actually. I got to learn about the program and understand, and they got to understand, with tariffs, things change really quickly. Just because whether it's moral character or a law school inspection, those can be good experiences. And I'm sure they are in many respects. So this is my long-winded way of saying, I would love to help think about different ways we can integrate some of that more experiential human data into the work of the California Bar.
Thank you, Crosby. Thank you. Comments further?
This is Julie. I just want to say, Crosby made some great points. I agree with all that he said. And then my question was to ask CS bars what they think about metrics, maybe at more of the student level, and if that's feasible. For example, how many repeats does it take for a student on average to pass the bar exam? Do they ever pass the bar exam? More on that level of data gathering.
Yeah, I think we do a lot of that now. But these are all good thoughts, and we will incorporate these going forward. What else? Anybody else? Okay. Thank you very much on that item, Natalie.
Thank you, everyone.
Let's move on to item 4.3, the mid-year status update and action, if appropriate, on the Committee of Bar Examiners work plan. And this is Donna.
Thank you, Mr. Chair and members. The staff report that was provided for today's meeting includes a description of those items on the CBE's 2026 work plan that either have been delayed from the date that was set forth in the work plan that was adopted in January, or that in some instances were completed in advance of the date that was set forth in the work plan. I think, if I recall correctly, largely the ones that were completed in advance had to do with the approvals of the business requirements and the rubrics for vendors for the first-year law students exam and the California bar exam, the approval of those vendors, the submission of the approval by the board of the business requirements and rubrics as well for the selection of a vendor for the California bar exam. You'll see that there, overall, we feel that we are largely on track with the work plan as set forth, as adopted in January, with those sort of few items pushed back by a meeting or two in order to, for a variety of reasons, but mostly read as we are trying to balance the workload of the committee and balancing the workload of staff. And there have been a few delays, but to the greatest extent, we are in compliance with the work plan. And this is an opportunity, if you've got some questions on the status of the work plan, you'll see one of the things that I have suggested as a motion is that you would direct staff to create what I termed a working version of the work plan to update those dates in my view, a work plan is really something that we set at the beginning of the year, and we're not amending it every month. But I would like to recommend that we create a working version that will have those updated dates, so we can make sure that we remain in compliance with those updated dates. Just as a quick reminder, this item of a status update on the work plan was added at our last meeting. The plan is that there will be an item on consent for every meeting, but at the mid-year point, which is the June meeting, that we would have this opportunity for discussion. Obviously, at any meeting in which it is on consent, a member is free to pull the item from consent, so we can have a discussion at that time if there are particular items that you wanted to talk about. But we did want to really be able to have this mid-year recap at this time. I apologize. One of the things that I did not do was mathematically catalog the items on the work plan and the percentage with which we are on track for and the percentage with which we aren't. A lot of the items are ongoing, and so that would be a little bit more difficult to track that way. But that is one of the things that I can add to the extent the numbers make sense to do. I can add that for the next status report that we have for the August meeting. But really, this is an opportunity for your discussion about our progress on the work plan. So I will stop talking at this point.
Does anybody have any thoughts or comments or questions?
Yes.
Paul.
Donna, in the public comments for our April meeting, I don't have them right in front of me, but a couple of commenters made suggestions about improvements that could be made to the standards for, I think it was the legal services program and maybe one other, to make it easier for those programs to be able to get, say, retired lawyers and maybe others willing to participate. For instance, by reducing the MCLE requirements. Maybe I've forgotten the measures, but at the time, at the last meeting, I mentioned that we should think about those. It may be a long range project, but I don't see that on this list, and I'd like to add it if nobody else disagrees, just for consideration. I'm not sure they're practical, but they facially they sounded perhaps workable to me. And one of the things we're always trying to do is increase access to underserved communities, and legal aid providers are probably the first regiment of soldiers who do that, if you will.
The good news is that we don't need to add that to the work plan because it's on the work plan. It's in the special admissions rules. They were talking specifically about the Registered Legal Aid Attorney Program. And I think, Paul, you may recall specifically because you were so involved when we originally proposed these rules. But the rules that we will be bringing to the committee for discussion at the August meeting, we had planned to bring them at this meeting, but they got delayed till August. The rules will make some changes to the special admission, to the Registered Legal Aid Attorney Program. We had talked previously about rules that align pretty well with the comments that were made by the Legal Aid Association of California at the last meeting. Things that limit the rules that would eliminate, proposal that would eliminate the requirement that you can only be in the program for 5 years, limitations on your entry into the program if you have taken the bar exam recently. There are a variety of proposals that we are looking at for that very program, for the very reasons that you said. Our goal, and one of the goals in the Board of Trustees strategic plan, is to increase participation in the special admissions program to provide greater access to legal services, and doing that through the Registered Legal Aid Program is an important way to do that. One of the things that you'll also see being discussed, being raised as part of that, we have had requests from Public Defenders Association to include public defenders in the special admissions, in the registered legal aid program, to have it apply not just to legal services program. Whether that is something that the committee would want to do, I don't know, but that would also be part of that discussion of the registered legal aid program, registered legal aid attorney program, to see if there are other ways that the committee wants to expand this special certification to allow people who are not licensed in California to provide legal services to really those who are most underserved.
Okay, and then my second question was about the change to or at our April meeting, you recall we were considering the eligibility rules, and we specifically split off the change to the statute so that it could go to the Board of Trustees and be hopefully part of the legislative proposals for this year. But subsequently, you reported that you folks decided that there was no way to get it into the to this year's package, and therefore it's been postponed. I just want to confirm that that delay is not going to cause us significant issues with trying to improve the eligibility requirements in the near future.
Yes, so the plan will be to advance that as part of the 2027 legislative priorities, as opposed to the being able to move them this year. We just did not think that there was a realistic opportunity to be able to move them at this late date. So we will be considering the eligibility rules. I think those are planned for consideration in 2027. And so we will be, but if we are not starting to look at those rules until 2027, with the idea that they come to the committee at least on 2 occasions before we refer it to the Board of Trustees to go out for public comment, then after public comment, back to the committee, then back to the Board of Trustees, advancing this proposal in 2027, which would have an effective date, if adopted by the legislature, of January 1, 2028, would not be out of line. I don't see it as likely being out of line with the timeline for the adoption of the rules.
Yeah, I just noticed it because you folks insisted in April that it would help us to break it out, and so we did that to no apparent effect. But thank you.
Any other comments or questions? Okay, thank you, Donna. Moving on to item 4.4, adoption of the content validation panel procedures and subject matter review procedures for the bar examination questions following action by the Exam Development Committee. Also, the delegation of authority to the committee chair and vice chair for approval of the framework for examination development. This item is being presented by the Office of Admissions Principal Program Analyst Adrian Galong, along with support from Ashley Silva Guzman.
So that was a mouthful, but before we do that, can we go back to the last item because we did not take a motion?
Was this? I didn't realize this was an action item.
But yes, there is a motion. Devin is projecting that now.
I'm sorry. Everybody see the resolution. Do I have a motion? Anybody?
Just Bolton move.
Dr. Bolton, thank you. Moves. Is there a second?
I second.
Ashley beat you to it, Crosby. We'll get you next time. Devin, please call roll.
Bolton,
Yes.
Burns,
Yes.
Cow,
Yes.
Gongora,
Yes.
Kaplan not present, Kramer,
Yes.
Lawrence not present, Lee,
Yes.
Macy Walla,
Yes.
Montgomery,
Yes.
Reed,
Yes.
Reyes,
Yes.
Reina not present, Silva Guzman,
Yes.
Smith,
Yes.
Yokelson.
Yes.
With 13 ayes and 0 nays, the motion carries.
Thank you, and I apologize for that. So without repeating item 4.4, is Adrian here? There he is. Adrian and Ashley, go ahead.
Sure. Ashley, if it's okay, I'll go ahead and take this.
I was going to say I can jump in if you need.
Of course. Thank you. So for this item, we are asking that the committee take two actions today. First, to ratify the content validation panel and subject matter expert review procedures for bar exam questions, following action by the exam dev subcommittee. And then second, to delegate authority to the committee chair and vice chair for approval of the framework for exam development. So on May 13th, the subcommittee discussed proposed updates to the question review procedures that align with psychometric best practices, other jurisdictions, and other high-stakes exams to ensure that we are prepared to timely act and begin the necessary development steps once the Supreme Court issues its decision on the future of the California bar exam. Pursuant to their charter, the subcommittee is required to submit policy recommendations to the full CBE. While their recent action could be seen as adoption of procedures, the subcommittee chair and staff felt it was important to present this item to the full committee for your support and ratification. As you know, we utilized content validation panels to review the multiple choice questions drafted by Kaplan Exam Services for the February 2025 exam. Although those panels were led by the State Bar's contracted psychometrician, we did not adopt at the time a comprehensive set of processes or procedures for validation and review of those multiple choice items. However, all panels evaluated items using the same criteria. Is the item legally accurate? Does the item appropriately test for minimum competence? Is the item free from bias? Is it clearly written? And is the style cohesive with other items? As we plan for future development, staff determined it was necessary to have a comprehensive framework to ensure consistency in processes between panels, to ensure we had determined in advance how to address disagreements among panelists and between the panels and exam developers, and to be broad enough to apply to any future exam development efforts. Staff, we have been working with psychometricians and consultants to create item review procedures that are aligned with psychometric best practices, again, other jurisdictions, and other high-stakes exams. The goal is to have the framework finished before restarting the constant validation panels and question review. In the event that the entire framework is not complete, we will not proceed until all procedures relating to the content validation panels and the subject matter expert processes are. We believe it is essential to have these processes fully documented before relaunching this effort. This brings us to the May 2026 subcommittee approval of the updated question review procedures for inclusion in the framework that is currently being developed. So attachment A that was posted online as reviewed by the subcommittee in May includes a reminder of the current processes and the updated procedures we are presenting and seeking committee approval for. Let me share my screen. If okay, I wanted to jump to slide 11, where we see the independent asynchronous work of the content validation panelists. Panelists, they will independently assign yes or no judgments for each of the criterion. While there's no discussion, panelists can record comments. And then group discussion will occur if there are any panelists expressing concerns regarding legal or technical accuracy, or for the minimally competent applicant appropriateness. Or if there's more than 40% of the panelists, or if one panelist makes the specific request, expressing concerns regarding content map alignment or bias and sensitivity. Items will be approved as is if there are no triggers, and we'll move forward to the subject matter expert review. Next, we're going to go to slide 13.
So just to be clear, this is one of the procedures that was presented to the Subcommittee on Exam Development that they approved, this idea of trying to streamline and make really efficient the time that the content review panelists have together as a panel by not going through every item in which there is a single comment, but rather creating this hierarchy of items for which we take the written submissions and we use those written submissions to improve the item, or versus those items which they'll bring up for group discussion. So this was one of the things that we wanted to sort of bring your attention to. This was approved by the subcommittee, and we'll be asking for your approval at the end of this presentation.
Thanks, Don. Next, I want to go to slide 13, where we see the post-discussion meeting revisions and final review procedures. Items flagged as revise, remap, or reject by the panels. Those will be returned to Kaplan. Kaplan will have 30 days to return those items, which will then be reviewed by a lead panelist. So instead of going back to the full panel, there will be one lead panelist per subject area, and the lead must have participated in the original discussions. Lead panelists, they will review the revisions against the provided feedback, and they will provide a recommendation for approval, which would advance the items to the subject matter expert review, or recommend not approved, but then providing additional feedback to Kaplan for additional revisions. And then that same lead panelist, they'll conduct any subsequent re-reviews. And then in terms of escalation, items that fail lead panelist review twice, based solely on legal accuracy, those will be escalated to a subject matter expert review. For items failing the lead panelist review twice for any other criteria, those will be escalated to the EDGE team member that's assigned to that same subject bank for review. Here, the EDGE team member will review and determine if the item is approved and can move forward to the subject matter expert review, or if it needs to go back to Kaplan. And then here, this just notes the documentation procedures. Any feedback or decisions at any of the review levels, they will be retained for all items. This includes anything from the content validation panels as individuals or as a full group, from anything from the lead panelists, or even anything that comes from the individual EDGE team member that's reviewing. All right. And the next I want to talk about the subject matter expert review. Oops, sorry. Oh, there we go. Here on slide 22, we do see a similar escalation process. This is for the subject matter experts, where any items that fail the SME review after 2 rounds of revision, those will be escalated to the EDGE team member for their review. And then again, this will be that EDGE team member that is assigned to review that same subject area for the essays. Here, the EDGE team member, they will review and make the final recommendation to approve, revise, or reject. This decision will be binding and documented. And then again, similarly for the subject matter experts, any feedback, explanations, or decisions at any of the review levels must be retained for all items. This is anything from the SME or the EDGE team member. And then as part of their discussions, the subcommittee also approved a process for handling the need to deviate from the defined processes. Here on this slide, you'll see that this would only occur in limited circumstances and should only be exercised when needed to support the integrity, security, or administration of the exam. When granted, this decision must be made by the Chief of Admissions. And then the decision must document the affected items, the step or the steps being bypassed, and also the rationale for that exception. And so today, again, the subcommittee and staff, we recommend that the CBE ratifies the action of the May 13th subcommittee action by approving a resolution. And let me pull that up. As I do pull that up, do any members have any questions? I know a number of the members here are also members of the subcommittee. And again, we also have the subcommittee chair, Ashley, here.
Let me just note, Adrian, that the resolution that was adopted by the subcommittee included, in addition to that escalation policy, the deviation policy, which is noted in the staff report, that the deviation, and I'm not looking at the language right now, but the not only must it be approved by the chief of admissions, but it needs to be reported to the subcommittee and then I think ultimately the full CBE. I don't have the language in front of me, Adrian, but if you've got that language, I can certainly pull that up.
Are you saying that should be added to the resolution?
No, I'm saying that by ratifying the action of the subcommittee, you would be approving that. Hang on, I think I have it here. No.
So that was in their resolution, which should then be
yes
in the agenda item.
I believe it is reflected in the agenda item.
I have it up if you want me to pull it up.
Yeah, please do.
You got it.
While you're doing that, was the EDGE team consulted in this process?
We did. We met with the EDGE team prior to let them know of the possibility of the additional work.
And did they provide any feedback, or were they even given the opportunity to?
I have to go back to my notes. I don't think that they had any specific feedback against it, but they did support the procedures.
Okay, good. Second question is, why the need to delegate? Is it time sensitive or considered to be so minor that it doesn't require our attention, either at the subcommittee or the full committee level?
It is time sensitive. The plan is to have the entire, frankly, part of it depends on what the order of the Supreme Court is going to be about about the future bar exam and what we might need to start developing. So should the Supreme Court direct that we return to the use of Kaplan developed multiple choice questions in 2028, we are going to need to launch the content validation panel review process and the subject matter expert review process pretty quickly. And so we want to be able to ensure that we either have the completed framework, or at least if we can't have that, the content validation process and subject matter expert process sections 100% complete before we launch that process. And so we don't have the time to necessarily wait for the August CBE meeting. And so that's why we are requesting that delegation.
Why not to the subcommittee itself, or is that too hard to assemble?
I think it's difficult to assemble, and because we still have to meet all the notice requirements, and it would be very difficult to assemble that in a timely basis. I mean, we could set a meeting for July 20th, and I'm picking a random date here, and cancel it if we need to. That's certainly an approach, but it is also, to the extent that this is a lot of the document will be very process oriented, and so we felt that the review by the committee chair and the subcommittee chair would be appropriate. Should you feel the need to direct that we convene a meeting of the subcommittee, then that is certainly something that that we would do.
I see that this is all low risk. So I'm not, in general, I'm leery of delegating to just one or two people to speak on behalf of the full committee. Less so here. And in fact, in our consensus document, the whole notion is that the officers are not supposed to act independently of us, but are supposed to, whenever possible, make sure we can consider things. But I think that it would be okay here. I would just suggest, though, rather than saying the chair and the vice chair of the committee, you say the chair of the committee and the chair of the subcommittee, because those roles could change over time. There will be some turnover in October. And I think that's more precisely what you're talking about.
It is.
And then let's see, do you envision these processes to have utility should we be directed to go with next gen, but also add a California component that we'll have to develop? Would they work equally well for that, perhaps?
Yes, that is the plan, that this would work equally well for any of our development efforts. Obviously, whether we're looking at first year law students exam, California component, a brand new California exam, the intention is that we would have a framework that would apply to any of those development efforts. We may look to modify it a little bit depending on the specific development effort that we have to go, but the plan was that the framework would be broad enough to encompass any of those efforts.
Great, thanks.
Anybody else? Okay, is there a resolution on the motion? There it is.
And Paul and Donna, I made that change for the. It said it already, but I just made it more specific. So the authority to the CBE chair and the subcommittee chair.
Okay. Should you name the subcommittee just to be even clearer?
Oh yes, you got it.
Okay, is there a motion?
I'll do that.
Paul is moving. Crosby, you want to?
I second.
All right.
Before you take the vote, if I just might add, so the what you are adding by ratifying the action taken by the subcommittee, the specific language that was added to by the subcommittee was a requirement that any exceptions to the procedures, right, in addition to being approved and documented by the chief of admissions, must be communicated to the chair of the subcommittee on examination development and an update provided to the committee of bar examiners at their next regularly scheduled meeting.
Yes.
Okay. All right, Devin, please call the roll.
Bolton,
Yes.
Burns,
Yes.
Cow,
Yes.
Gongora,
Yes.
Kaplan not present, Kramer,
Yes.
Lawrence not present, Lee,
Yes.
Macy Walla,
Yes.
Montgomery,
Yes.
Reed,
Yes.
Reyes,
Yes.
Reyna not present, Silva Guzman,
Yes.
Smith,
Yes.
Yokelson.
Yes.
With 13 ayes and 0 nays, the motion carries.
Excellent.
Thank you, everyone.
Thank you, Adrian. Ashley, thank you for that work. Item 4.5, action on issuance of non-compliance Pacific American University School of Law. That has been withdrawn. So we'll move on to item 4.6 is the review of the February 2026 bar exam results. This item is being presented by Principal Admissions, or Office of Admissions Principal Program Chair Analyst Lisa Chavez. Lisa, are you promoted? There you are. Hi, Lisa.
Hi, good morning, everyone. I'm going to share my screen and we will get started. I'm pleased to share with you a slide deck that we shared with the Board of Trustees at their May meeting that had preliminary results for the February bar exam. I'm sure you're aware of some of the results that were released as part of our press release. But what we're going to do here is just we want to start doing on a regular basis with you and our board is to not only present results that describe the most current, exam but also to start looking at trends. And we've chosen the 5-year trend mark to consider trends. We're also starting to try to do a little work into understanding trends that we see. So let's get started. Okay, first let's talk big picture here on the left. As you all know, the general bar exam pass rate was 30.8, and the attorney bar exam pass rate was 57%. 60 general bar exam applicants received a scoring adjustment, resulting in 5 passing the exam after that adjustment was applied. We did an analysis to look at what that unadjusted general bar exam pass rate would have been, and it was very negligible. It would have only been 30.7%. Up here on the right, again, this is looking at the trends over time, whether we're starting to do a little bit more thoroughly, is we're looking at the number of applicants that sat for the exam. And as you can see, the total number of general bar applicants remained over 3,900 in 2024, as it was in 2024. The number of first-time applicants really increased sharply in 2026 in comparison to 2024. The only reason why I'm referring us to 2024 is because, as you all know, February 2025 was a unique bar exam. We had a lot of people withdrawing, etc. However, those numbers are presented here. The number of repeat applicants really declined in 2026 as compared to 2024 after several years of year-over-year growth. And we think that that's likely attributable to the February 2025 exam's very high pass rate. So now what this shows is pass rates over time for 3 categories of applicants. Again, this is focused on the general bar exam. For the total applicants, the first-time applicants, and repeat applicants. And what we see here is a 5-year low in pass rates across all 3 of these applicant groups. And particularly for repeat applicants, you see a really strong drop. Of course, we see a consistent advantage for first-time test takers. But again, there's a really sharp decline among the repeat applicants. The pass rates for repeat applicants just declined by 6 percentage points. And this is really offsetting improvements that we saw in these years right here in 2023 and 2024. As part of our interest in really getting into understanding those results for February, we took a look at, we're trying to take a little bit more in-depth look of the applicants who sat for the exam. And on the here left is, this shows, okay, so remember there's 3,900 applicants that took the exam in February, for the general bar exam. What this shows is the category of applicants. As you know, we have general applicants who graduated from a law school, and they are assigned the law school that they graduated from, the category of law school. And then we have attorney applicants. And so we have foreign attorneys and U.S. attorneys. What this table shows is the distribution of the applicants across these categories, and it's sorted from high to low. And what you should take away here is that foreign attorneys and graduates from our CALs are the 2 largest groups of applicants who took the exam in February, followed by graduates from a California ABA approved school. The reason why this is significant, because when you look here on the right, we see that foreign attorneys and applicants from the CALs, remember I just told you that the 2 of the largest groups, they have among the lowest pass rates. As you can see, foreign attorneys, their pass rates are 23.8, and applicants from the CALs, their pass rate was 29.7. U.S. attorneys, on the other hand, have the highest pass rates among both first-time and repeat applicants. Again, so this is just a line of analyses we're trying to understand to help us in our understanding of these results that we're seeing. And this chart here again shows for each of the 4 main categories of law school types year-over-year trends. As you can see, ultimately, this is a very sustained trend, is that we see the highest pass rates among the California ABA schools. That's up here at the left. We We see an interesting marked improvement for our California unaccredited first-time applicants. These are them right here on the right. As you can see, their pass rate went up to 53%. However, it should be noted that this group of applicants from the California accreditation who 53% passed, it only represents 15 applicants. So that's a very small number of applicants. And as you can see, first-time pass rates increased for most school applicants, for most school types. However, the repeat applicant pass rates reached a 5-year low for all of these schools, except for the California ABA. And then here again, again, we're trying to really understand pass rates for all our applicant groups, including our U.S. attorney applicants and our foreign attorneys. And as you can see, the U.S. attorneys really, this is when I said that they had the highest pass rates, this is a really trend that's very consistent over 5 years. But however, in 2026, they did have mixed outcomes where their repeaters had a lower pass rate. And foreign attorneys, there's a really sustained decline we're seeing among the foreign attorney first-time pass rates. As you can see, it really peaked here in 2022, and it's just going down consistently, again, among our first-time foreign attorney applicants. And the repeat pass takers, however, really is kind of remaining unchanged. And now here I'm going to just skip through this very quickly here because these are results we've discussed before and really getting at racial ethnic differences. Here on the left is this shows that Asian applicants make up the largest group of applicants, followed by white applicants. And here on the right, we show pass rates for our different racial ethnic groups, disaggregated by whether they were first-time or repeaters. And white applicants had the highest pass rates among all racial ethnic groups among the first-time applicants. Another notable trend we see here is that Black and Latino repeat applicants had the lowest pass rates, and they really stand out because they were the only two groups that had pass rates below 20%, and that's here. And this chart just shows trends over time. In the interest of time, I'm just going to go ahead and skip through and go ahead to our gender analysis of gender. Again, we're taking the same approach. Which group comprises the biggest group? It's actually women. Women now comprise nearly 60% of applicants. However, if you look at pass rates, men had higher first-time pass rates compared to women among first-time applicants. However, there are no gender differences among the repeat applicants. And then again, here we see some trends. We had trend data by gender. Okay, all right, but I'm so sorry. What you should take away here is that there's a really consistent gender gap in first-time pass rates. Okay, I'm happy to take any questions you may have about this data. Thank you so much.
No, I had a question.
Thank you. Who has a question?
No, I had a question, Vince.
Go ahead, Vince.
I'm just wondering on the foreign attorneys taking the test, are there any, are you tracking what countries that we're categorizing under foreign?
I'm not aware of this. I will defer to my colleague Tara Clark. If that information, I know that we don't report on this, but whether we have this information to do an analysis, I'm unaware of that.
Sorry, Vince, could you please repeat the question?
Yeah, under the foreign attorney category, are we keeping track of what countries were considered in that category? I'm just curious.
We do have the information, but we don't compile it with the bar exam statistics.
Okay.
Michael.
Oh, yes, that was just a sub-comment off of Vince, is that may be something we might want to take a look at, because in other bar associations that I'm a part of, they draw a distinction of an applicant. Are you a common law applicant or are you a civil law applicant? And maybe there's a variation that we'll find there, that applicants from legal systems similar to ours maybe pass at a higher rate. Those that are from a dissimilar legal system maybe do not, and maybe that guides them to additional preparation or something like that.
Yeah. Thank you for that.
So going back to the point that Crosby made earlier, which is a conversation that staff and I have had a lot this year. So Michael, if you can help sort of, what would we do differently by having that information?
Yeah, I think maybe it's just informational about whether there's greater preparation that's needed on the applicant, that the the applicant knows that people who are not from a legal system similar to the US need greater application. And maybe nothing that we need to do on our end. That's just a curiosity.
Mm-hmm.
Alan, this is Michael. Can I
Yeah,
ask
Michael.
a question? I guess I wanted to ask Lisa. So you mentioned that the US-based attorneys have the highest pass rate. I'm just curious, do we have age demographics? Are these attorneys that have been practiced over 20 years? Are these attorneys that are fresh graduates out of other ABA law schools throughout the nation? I guess that's my first question. And then my second question is that for the repeat test takers, do we have any demographics on whether what percentage of the repeat test takers take bar prep classes, and does that also affect their bar pass rate for the second time test takers or the repeat test takers?
With regards to the U.S. attorneys, we have not analyzed information with regards to, in other words, do a deep dive into this population in terms of learning their age, their law school type, it's how long they've been practicing in other jurisdictions, but that's something I believe that we could do because I believe we have that information. With regards to repeat test takers, I don't believe we've done an analysis that shows among the repeat test takers, among those who have engaged in different test taking. However, we do administer a post-exam survey, and we do ask, did you participate in any of these different, institutionalized programs versus making use of bar prep materials, et cetera. But we've never analyzed that survey data by attempt status, and I think that would be a really interesting line of analysis.
Okay. Anything else?
Yeah, I mean, just building off member Cal, as I think about the repeat, and it looks like about 1 in 4 people pass that, and that seems like it's pretty on par with some other states. I'm wondering what kind of public communication or support or what we do to those folks. One, how much do we market? Like, hey, generally 1 out of 4 people don't pass the next time. Not that we should dissuade people from taking it, but at the same time, we should be full-throated and, hey, it's the chances are lower than average. And what is our strategy if we have one? If not, to say, hey, those folks, we want to see them passing it at a higher rate. And so how do we help inform our consumers to say, you should consider retaking it if, based on what we know, if I were doing a multivariate analysis, these 3 things are the key ingredients to be among those that pass. You should consider not if X, Y, and Z, and helping guide the takers a little bit. It's an opening rhetorical question. I'm sure we don't have those answers now, just food for thought.
Actually, I'll get to you, Ashley, in a second. Actually, philosophically, Cosby, I'm not sure we should be doing that. We're a public protection agency. The data is out there. It's very clearly published. We do everything we can to make it a fair and equitable test. But at the end of the day, I think it's up to individuals whether or not they want to attempt it. So we should have this discussion some more when we get together in person.
Yeah, I appreciate the perspective.
If I can add, though, we do actually have 2 programs available one for all bar exam takers, such as the Bar Exam Strategies and Stories. Then the Lawyers Assistance Program of the State Bar also has specifically a bar retaker support program. So that's something they had launched in the recent years that's available. And we do targeted communications to those applicants.
Ashley.
Yeah, and I think one of the main concerns I would have with kind of putting out something similar like that is that a lot of times repeat takers, it's a mental game, right? It's either mental or it's resource based, right? I mean, some people just can't afford to take this bar multiple times year over year over year. And so you have kind of the issues, the compounding issues of you're psyching yourself out on a multiple exam, and then to hear from the bar, hey, also you have you're 25%, whatever, in this 25% that's likely to pass, but otherwise, good luck. I think that might harm the kind of mental upkeep that's required to restudy for the bar, take the bar, and pass the bar. And if they want to seek out that number, those numbers on the pass rates, I think that's good for them. But I think the people who are seeking those numbers out know it would be good for them. I don't think in emphasizing those numbers, it could have a counter effect. It could cause less people to pass because now it's really in their face. Hey, this is how low of a chance it is, when it really isn't, right? It's very individual based, I think, but that's another issue.
And as one of the non-attorneys, one of the few non-attorneys who has not gone through the wonderful psychological journey that is the California bar exam, I can appreciate that perspective.
I would also note that statistic, I'm not looking at the numbers, but I'm trusting your 1 in 4, that is aggregate. And one of the things that the data does show is the more with each sort of increase, with each repeat attempt, the chances of passing are less likely. So somebody who is on their second attempt has a much greater chance of passing than somebody who is on their 20th attempt. And we do have people really across the spectrum, second attempt, third attempt, 50th attempt. So it's really across the spectrum. So that I would want to disaggregate that number if we were going to do anything, because I think people who for whom it's their second attempt, have a much higher chance of passing than somebody at a sort of higher number of attempts, right? Everybody has a bad day, and that bad day for somebody might have been that first time they took the bar exam, and so that's I think why they have a higher chance of passing than somebody who's on their 4th, 5th, 10th time taking the exam.
Anything else? All right. That was a great presentation, Lisa. Do we have a resolution on this? No action. All right.
Thank you.
Lisa, thank you very much.
Thank you. You're welcome.
Let's move on to item 5.1, oral report from staff. Donna?
I think Tara actually has most of this presentation. I think I chime in toward the very end.
All right.
And
Tara, then Donna.
Thanks, Alan. So we just have a couple of quick updates for you. So we have our June first year law students examination. So we had our application closed mid-May. The exam will actually be on June 23rd. So we are administering it at Prometric test sites primarily. So about 80% of the applicants are signed up to test in person, while about 20% are signed up to test remotely. Then we will have those results in early August for those applicants. And for our July exam, it's coming up in next month, it's already here. So our application closed on June 1st. So we ended up with just over 9,500 applicants. We had 444 applicants use the waiver, and that was out of a pending 1,018. So there's still about 574 who did not use it. That number will slightly varies based on the withdrawals. The withdrawal deadline is not passed yet. And these numbers are as of, you'll see, last week. But we had about half of the applications had already been approved, half were pending. And then we have seen a significant increase again in our requests for testing accommodations. You'll see we had approximately 1,525 applicants requesting accommodations for this exam. And for 2027, so we wanted to give you a quick update since our team is already working on securing locations for 2027 and 2028. So this may actually surprise you to hear, but we actually have more difficulty finding sites for February, even though it's a smaller population. And we've just found, I think, that more agencies or conferences are happening around February, so there's more limited ability. However, we do have several sites secured already. For February in the Sacramento area, we're potentially going to look again at that Vacaville site we had. It was a much smaller location, so it's not our first choice, but it did run smoothly. We're also looking at Stockton. Then if we go down to our standard sites, in the Los Angeles area. So we do have the Ontario Convention Center, which is obviously one of our largest sites, both February and July, but looking potentially for a second site specifically for July. I know we've heard from public commenters that they do like the Anaheim site. That one's typically not available, but so we are looking for an alternate for somewhere near Pasadena right now. And then on test and accommodation site, pretty well, doing well so far. You'll notice for the Bay Area, we have tentatively Weston St. Francis, which we're using for the first time in San Francisco for this exam, and then potentially UC Law San Francisco. So that is one that's pretty close to our office. A couple staff members, we did a tour recently, and we think that it'll likely fit our needs. So we'll see which route we go for that exam. And then for the LA area, again, for July, just looking for some more space on the testing accommodation side. Okay, and we have additional updates. This is very quick. So I think all of these were covered earlier, maybe except for the first one in the update to the work plan. So just as a reminder that the revised rules for the Law Office Study Program and the Certified Law Student Program, which was formerly known as the Practical Training of Law Students Program, went into effect on June 1st. So those revised applications and the information on the website and FAQs, that is all up and running now. And since everything else was touched on, I will pass it over to Donna and we can take questions at the end.
Okay, thank you, Tara.
Yeah,
Donna?
so the last thing I just wanted to mention was the very last bullet point on here, which is the petition to the Supreme Court on the future of the bar exam. The chair mentioned this in his oral report, but last Friday, the petition reflecting the recommendation of CBE and the Board of Trustees, which were the same recommendation, that petition was transmitted to the Supreme Court. The recommendation, as a reminder to everybody, was that the court order the adoption of the next-gen uniform bar exam for the July 2028 bar exam, and that we then subsequently add a California component. We asked the Supreme Court to, if they agree with that, to give us a recommendation or direct us on what subjects and skills are to be tested on that California component, including, and this was a refinement that was added by the board, including specificity on whether in testing that, in adding that subject to a California component, we are testing California law or laws of general application. We are expecting that the court, after giving appropriate consideration to the recommendation and the risk-benefit analysis that helped drive the recommendation, will issue its order in mid-July. That will give us appropriate time to meet the statutory notice requirements, which requires 2 years' notice of the change to the bar exam. So we would be able to do that before the end of July 2026. We have developed a communications plan on how we would provide that notice, and we will keep you updated when we hear from the court.
Okay, pins and needles. All right. Tara, I had a question. The waivers, the fee waivers?
Yes.
This is the last opportunity to use those?
That was this exam. So that number, for those who used it, it would only change if folks withdraw from the July exam, but this was their last opportunity.
Right. So do we anticipate that there will be some fee waivers just not used? Sounds
Yes.
like it. Okay. Just be curious at the next meeting to see what that number is.
So right now we're at 574, but we can bring an updated number after the withdrawals and the no-shows.
Yeah, I'd be curious. All right. So are there any questions or comments on this report? Seeing none, we are at the end of the open agenda. We are way ahead of schedule. So what I'd like to do is propose we take a 10-minute break and then reconvene in closed session. That would be at 11:30. So let's take or 11:32. So let's take a 10-minute break, and we'll see everybody in closed. Thanks, everybody.
Before you go, do you have any anticipated return time out of closed?
Yeah, I was just wondering about that. I'm going to go with 12:15, but that may be actually liberal. It may actually be sooner. So members of the public, please check back in around 12 o'clock for coming out of closed. Thank you, everybody. Take 10. No, there's nothing reportable from the closed session. The meeting business has been concluded. Is there anything else anybody wants to bring up? Seeing none, the meeting is adjourned. We'll see everybody in San Francisco. I believe it's August 21st. Thank you very much, everybody, and thank you, Donna, for setting a great agenda. Thanks, everybody.